timetable.
Human rights, just the last point on human rights.
I was asking how long are you proposing to...
I'm so sorry, you're quite right. 3 o'clock, I should finish at 3.
Right.
So far as human rights is concerned, we set out our arguments in relation to human rights, and I would just ask your Lordships to note that if your Lordships do go into the question of Article 1, Protocol 1, and whether or not the interpretation of the legislation that we suggest has to be considered in that context, then an authority that we don't mention, but which the Secretary of State does mention, is a case called Barner and Sweden, which is in Volume 10, tab 108, and the Secretary of State refers to it in paragraph 98 of its submissions, and we would rely on it, suggesting that there is no infringement of Article 1 in any event. If I can now turn to, before I move on to trespass, if I can just make some points in relation to the assessment of damages. And this is dealt with by us in the printed case in 185 to 197. Well, there it is. I would just like to make 1 or 2 comments in relation to paragraphs 193 onwards. And this, therefore, is the extent to which the court should it be found that we are wrong, and the Court of Appeal is wrong, how the court should approach the question of the assessment of damages. Again, there it is, and all that I really want to do is just to make some additional comments. First, I would ask your Lordships to note that the trial judge stated that both experts, in his view, suffer from a lack of objectivity. This is paragraph 79 of the judgment below, and he, in effect, took his own course, relying, because of the view that he took in relation to BP and Ryder, more upon the evidence of Mr. Crawford. So far as the experts were concerned, they were polarised in this way in their evidence. Mr. Crawford assumed that BP and Ryder was wrong, and so it was a free, unrestricted negotiation. Mr. Smith assumed that BP and Ryder was right, and therefore it was a question of assessing, in effect, the compensation that would be payable under the Acts, and what the parties would therefore have agreed in that context. It therefore, so far as the evidence of the experts is concerned, would not make any difference at all to their evidence if the court were to find that the relevant statutory context was the Pipelines Act 1962, wouldn't affect the evidence in any way. A point has been made by us in paragraph 195 in relation to the Attic oil, 38,000 barrels. I have to correct something here. Mr. Gaunt is right. The position was not that the difference was between drilling down vertically and not diagonally. The point here, so far as the Attic oil was concerned, was a different diagonal or deviated drilling, and so my references to, our references, I should say, to vertically in 195 and anywhere else you may find it, is not completely correct, but nor, so far as we're concerned, is quite what Mr. Gaunt said. I'm going to deal with this very quickly, if I may, by handing up to the Lordships a report which is not in evidence, but none of this, in fact, is part of the agreed statement of facts. It was, when I say it's not in evidence, it was in evidence before the trial judge. The point I'm going to make is a very short one and a very small one in the great scheme of things, and in all the circumstances, I want to make it as quickly as possible. This is the supplemental expert report of Mr. Wright. Mr. Wright, in fact, not Mr. Ahrens, as Mr. Gaunt suggested, is the person responsible for arriving at the Attic figure for Attic oil of 38,000 barrels. On any view, even if one drilled into the apex of the reservoir, it was estimated that 30,000 barrels would never be recovered. So there's always going to be a 30,000 barrel would not be recovered. You would, if you turn to this in this report to page 145. You can see there the diagram that you were taken to, which shows a relocation of the wellhead and the wells drilled outside Bocardo's land. On that footing, you will see, if you look at resource, that would have meant that there was 134,000 barrels that were not in fact recovered, compared to the 30,000 if one drilled into the apex. This, in fact, is Mr. Ahrens' map, and it would produce a lack of recovery of some 134,000. In fact, Mr. Wright's analysis is at 144, and this, in my submission, is the correct one. Again, I hope I'm not taking this too quickly. I don't want to waste a lot of time on it, but you'll see that the thick dotted line, as opposed to the dotted lines, where the dots are closer together, but ones that are more spread out, the dash.
You're muttering a little bit, Mr.
I'm so sorry.
Yes, go on.
The dashed line on 144.
Is that going at 11 o'clock, as it were?
Yes, 11 o'clock.
Yeah.
That is the suggested rerouting of the pipeline. That is the rerouting that would have produced under recovery of 68,000.
Is that as opposed to 30?
Yes, and that is where the 38,000 barrels comes from. That's referred to in the judgment. As you can see, it's not vertical, it is deviated. It's different deviation to the one that was suggested to you. I'm therefore, at this point, seeking merely to correct what we think is an inaccurate explanation to you. But at the end of the day, what I have to accept is that even with this, this deviation, it would have meant a deviation under the land of a third party. Not Bocardo, but a third party. And so, whilst I thought it necessary to draw this discrepancy to you, it doesn't at the end of the day make a great deal of difference to the argument, except, of course, on this basis, as the map I've just shown you, there is no need to move the wellhead, which I think was the suggestion. If I can just now take you to...
so what's the bottom line of all that?
The bottom line is that I'm just probably being a bit of a pain by correcting what we think is an inaccurate description that's been given to you, but at the end of the day it doesn't make any difference.
You get the same result.
Yeah.
So it's the first sentence of 195, your 195, correct?
It's not correct, no, it wasn't drilled, it wouldn't, it's not the difference between
I beg
drilling
your
vertically and not
pardon.
diagonally.
Sorry, yes, because of the vertical part.
Yes.
Yes, thank you.
But also that
Yes.
Mr. Gaunt's, the plan that Mr. Gaunt relies on, the diagram that he relies on, is
Yes.
not the correct one. The
Right.
correct one is the one that I've just pointed
Yes.
out to you.
Yes.
We have some comments to make on Mr. Crawford's evidence. They are set out in paragraph 196. Could I just ask you to turn to subparagraph 2 on page 82? Of our printed case.
From the printed case.
Page 82.
Yes.
What does the paragraph say?
Mr. Crawford wrongly assumed.
Thank you.
The approach that both sides have adopted, which may have to be completely reconsidered if the relevant date for the hypothetical negotiation was 2000, changed the evidence completely. So far as profitability of the reservoir and production costs and expenses and overheads are concerned. But both parties have assumed that the proper date for the hypothetical negotiation would be before the trespass started, is the word I've used, or cause of action in trespass accrued. And Mr. Gaunt suggested that Mr. Crawford had made the same assumption. In other words, he wasn't assuming, as the judge, we say, wrongly did, that the licence holder had already incurred the expense of 1 million per well. By drilling those wells, he therefore incurred 1 million for each of those wells, and therefore he'd already spent 3 million before he sat down and negotiated with Bocardo. We say that the correct approach is to look at what a negotiation prior to the trespass would have produced. And I did think that both sides were in agreement about that. Whatever the date is, whether it's 986, 982, 984, the assumption is you consider a hypothetical negotiation before the cause of action accrued when the pipes were drilled. Mr. Gaunt said that that was the same assumption as, that Mr. Crawford made, and therefore you're entitled to rely upon Mr. Crawford's report, in effect, if you find against us. And the point that we make there is that he did assume that in the hypothetical negotiation, the licence holder had already incurred an expense in drilling PW5. And you can see the references. I'm not going to ask you to turn to them. Those are the references, note 138. And I would therefore simply ask you to add to those references 219 and 242 to 3. They also make the same point. That's the supplemental report by Mr. Crawford, which shows quite clearly that he is assuming that in the negotiation, the oil company has already invested in one well, PW5, at the time of the negotiation, which we say is a wrong assumption to make. Again, at the end of, and just before paragraph 197 over page, just before 197, I would also ask you to note that it is our case, and we have looked through the documents which are available to your lordships and before the Court of Appeal to see whether or not this is right or a fair thing for us to say, but it is our case that Mr. Crawford has not brought into account the licence holder's liability to pay a royalty to the Crown. So his assessment is on the basis that the only royalty is one payable to the landowner, and that he has not taken into account the royalty to the Crown. As counsel, we didn't take part in the trial, of course, but and we've relied upon what we've read and been told. But that does appear to be the position.
And was all this said to the Court of Appeal?
My Lord, I can't remember whether or not that point was, but most of what you have to see in this case was put to the Court of Appeal as well. My own recollection is that the point was made to the Court of Appeal that an assessment of a royalty at 12.5% of gross revenue was surprising in light of the fact that the oil company also had to pay a royalty to the Crown, which owns the petroleum. At that time, it had to pay a royalty, and that royalty was 5.5% on the turnover, on the production. But that was the point put to the Court of Appeal. The Court of Appeal, of course, didn't have to consider Mr. Crawford's evidence. They decided that the right basis for evaluation was the no scheme basis. And so they accepted and based themselves upon Mr. Smith's evidence.
So the 5%, is that 5% of gross revenue or 5%
Yes,
of something else?
yes.
5% of gross revenue.
I think it's 5.5%.
In paragraph 197 it says 5%.
Well, that should say 5.5%.
Sorry, I didn't catch that. You say 5%, did you say?
5.5%.
5.5.
As I stand here, my recollection is it's 5.5%. It's in the...
We looked at it and I thought it
Yes.
rose depending on how much to 12 and a
Yes,
half.
that's right.
I thought it started at 5, but it's
Oh, well, then it may... My Lord...
flabbergasted me is that you're asking this court to start doing all sorts of basic calculations of this character. Well, there it is.
Well, the difficulty, my Lord, one difficulty is that if one does go down this route, the trial judge actually pursued his own course, and his assumed negotiation was on the basis that the 3 wells had already been drilled, and both sides, I thought, had agreed that that was the wrong basis. It was explained to your lordships that that was probably our fault because we chose 1994 as the date. Or whatever the date is, it's wrong in our submission to assume that the hypothetical negotiation takes place when the trespasser has already incurred an expense of 3 million in drilling the wells. The oil company is then in a very difficult
We don't get any help on this matter from the Court of Appeal, do we, in their judgment?
No, you won't. I'm sorry, I wish I'd not mentioned 5.5%. It's 5%.
Thank you.
Again, a small point, but before I now turn to trespass, and it was said in the Court of Appeal that one should assume generosity on the part of the oil company, and one factor so far as generosity is concerned it was said to be delay, but as we explain in paragraphs 187 and 188, the evidence was that delay in this particular case would not have made any difference, and you can see the references to the oil company. And so far as the last point that I just made is concerned, could I just ask you to look at the judgment of the Court of Appeal at paragraph 51. It's the last five lines of paragraph 51.
Yes. Yes, thank you.
Trespass. First of all, I will deal with the argument, which, if I can put it this way, almost succeeded in front of the Court of Appeal. It's set out in paragraphs 93 to 104 of the printed case. And it relies upon Section 1.1 of the Petroleum Production Act, 1934, and the correct interpretation of Section 10, subsection 3, and the easiest way for me to deal with this is to ask your lordships to turn up the Court of Appeal judgment in the court bundle. Well, Justice Aikins deals with this at paragraph 80. Paragraph 80 onwards.
It really begins at 79, I think, does it? And then where he sets out the
Yes, it's
problem.
79. The question is whether or not the right given by Section 1, subsection 1 of the Petroleum Production Act 1934, which confers on the Crown the exclusive right to search and bore for and get petroleum, justifies, in this case, the drilling of the pipes 800 feet and more below the surface of Bocardo's land. And our submission is that it does so unless it falls within the words of Section 10.3. Section 10.3 states that nothing in the Act confers any right to enter on or interfere with land. And our point, very shortly, is that these pipes do not amount to an entry on or an interference with land. Now, the Court of Appeal rejected that argument. Lord Aiken said that he found the question a difficult one and that he'd altered his view as to its effect more than once. But he said that it was impossible to read the 1934 Act in that way.
The word land not being defined in the Act.
The word land is not defined in the Act, no. As a matter of common law, if a right is reserved or granted to someone in respect to the minerals, so that ownership of the surface and the minerals is severed, then as a matter of implication, the owner of the minerals will acquire a right to go on to the surface in order to get at his minerals, or to get at his minerals by underground workings. It's an implied right under the law, and we cite authority for that in our case. It's a well-established principle in the case of conveyancing, an implied right. Here, however, we're concerned with a statutory vesting of title in the petroleum in the Crown. And it's therefore not a question of an implication as a matter of common law, but a question of statutory interpretation. Does the right given by Section 1.1, an exclusive right to search and bore for and get the petroleum, justify what has happened in this case, or, and this is the way we would put it, or is it not justified by the Act because it amounts to an entry on or interference with that? Lord Justice Aikins had essentially 4 reasons why he rejected that argument. In paragraph 81, he said that there is no express right in the 1934 Act which permits the boring of a pipeline at depth through land within the licensed area in pursuance of the license. Our answer to that is, but that is Section 1, subsection 1. You have an exclusive right to search and bore for and get petroleum. That's the right conferred on the Crown. The Crown then passes on that right to the licence holder through the licence. Secondly, he says in 81 that Section 3.1 expressly acknowledges that a licensee under the Act may need to acquire ancillary rights to exercise the rights granted by the licence given to it. And one of the types of ancillary right expressly contemplated is the right to enter upon, and I would emphasise that, upon land, and to sink boreholes therein for the purpose of searching for and getting petroleum. I've concluded, he says, that the phrase enter upon land is intentionally general and must embrace land within the licensed area. Must be right. Moreover, I think that Mr. Gaunt is correct in submitting that the phrase is broad enough to include entering into land beneath the surface. Well, for this purpose, you have to look at Section 3.1 of the Petroleum Production Act in 1934. The argument is a short one, but there is Section 3.1b. The right is expressed as a right to enter upon land and to sink boreholes therein. In my submission, that contemplates a right to enter upon the surface of the land. We don't find the word surface of the land, but if it's a single right, as it appears to be, a right to enter upon land and to sink boreholes therein, the reference there to a right to enter upon land seems, I suggest, to relate naturally to a right to go onto the land. And then, when you're on the surface, to sink boreholes in it. It's not a right to enter into the land, or under the land, or through the land. It's a right to enter upon the land and to sink boreholes therein for the purpose of searching for and getting petroleum. Now, in that context, the 3.1b context, in my submission, what Parliament has in mind is, as I put it, a right to enter upon the surface. It's a right there to enter upon land, and in my submission, that is no different from the words you find in Section 10.3, a right to enter on.
Well, it's a little wider, isn't it? Because it's enter on or interfere with.
No, I must deal with interfere, but dealing at the moment just with that part of 10.3, which is a right to enter on. Yes, I must come and deal with interfere with. But I do ask you to bear in mind that Lord Justice Aikins' approach to it, at the end of paragraph 81, is that the phrase, and this is enter upon land, is broad enough to include entering into land beneath the surface. That's what we dispute. He then goes on to say, thirdly, confirmation that the kind of ancillary right rights that might be required include ancillary rights for use of land beneath the surface, is found in the description of the types of ancillary rights in Section 3.2b of the 1923 Act, which includes a right of underground way leave. That phrase is, in his view, broad enough to encompass a right to bore a pipe through strata, as well as create and use a passage to get to and carry minerals such as coal. Well, that may well be right, but the 1923 Act, of course, is concerned with all sorts of minerals. And simply because in the list of ancillary rights that one finds in the 1923 Act, similarly in the 1966 Act, and it's quite a compendious list of rights, simply because one of them is a right of underground way leave, does not, in my submission, throw any light, any real light, on the meaning of entry on and interfere with land in Section 10, subsection 3.
I mean, if you're right, then you could enter somebody's land, I don't know, 20 feet below the surface. And, I mean, assuming you're not creating substance problems or something like that, which we would no doubt agree would interfere with the land, but you could very well, I don't know, inhibit the possibility of other subterranean use of the land in future without paying compensation.
Well, put like that, it might amount to an interference. You're interfering with land if you're in some way reducing the ability to use the land in the future. I think that's how I would put it. We don't have, if it's the drilling of a pipe 20 feet under the ground, then it could, depending upon the use that might be reasonably foreseeable so far as the surface is concerned, it might amount to an interference with land. But here, this pipe is 800 feet to over 2,000 feet below the surface.
Well, I know what it is here, but we're just testing the approach, all right?
Yes, but my submission that the test is one where the pipe may well be too close to the surface, if you like, 20 feet. But my point in relation to paragraph 82 is that simply because in this compendious list of rights there is a right of underground way leave, this is an act which is to deal with all sorts of minerals, particularly coal. Simply because there is that right does not, in my submission, assist in the construction of the 34 Act and the meaning of Section 1.1 and Section 10.3. And then 83, Lord Justice Aiken says there is the wording of Section 10.3. Section was clearly intended to protect the rights of landowners where petroleum might be found, whose rights might otherwise have been adversely affected by the grant of licenses. I take the wording of Section 10.3 to mean that if a licensee has a right by agreement, the common law or some other statute to enter on or interfere with land, the licensee can continue to do so. Furthermore, it can do so by exercising rights expressly provided for by the 1934 Act, ancillary rights. But apart from those rights, no other right is conferred by the Act on the licensee, and the Crown cannot, by license, confer any other right on a licensee to enter on or interfere with land. To my mind, the words enter on land in that section must include entering on land at depth. And that is how the Court of Appeal resolved it against us. They relied on the words enter on, and they say enter on in Section 10.3 means entering on land at depth. In my submission, that's a very strange use of language. You don't enter in land, you don't enter under land, you don't enter through land. Apparently, someone can enter on land at depth. It's a very, in a way, it's a very short point of construction. We say enter on land. Enter is very similar to enter upon land. Naturally means entering onto it, not under it. And then he says, I would be prepared to give interfere with land a practical meaning, such as having some deleterious effect upon the land or its use by the landowner, but that does not assist Starr in this case because it has entered upon Bocardo's land at depth. Well, we say that the Court of Appeal was wrong about entering on land being entering on land at depth. That is a strained use of language. But nonetheless, that interfere with land should be given the meaning that the Lord Justice has given it. It does mean an act which has some deleterious effect upon the land or its use by the landowner. And what we have here isn't one of those. There it is. It's a short point of construction where you can see that the Court of Appeal reached the conclusion they reached with some reluctance, having found the question of construction difficult.
And the premise of the whole argument, of course, is, as was here found by the judge, that actually it doesn't do one iota of harm to the owner.
Yes, yes, the Lordship is quite right. I'm grateful for that, yes. That is one of the three arguments we run on trespass. The first argument is that, as a matter of law, the owner of the surface does not own down as far as Bocardo claims to own in this case.
So you would accept that the owner of the surface owns down some depth?
Yes.
If there are, as it were, underground storage places and that kind of thing, he can go down into the ground to provide himself with an underground store,
yes,
or for digging drains, or that kind of thing. But you say there's a depth beyond which you can't go. The question then is, how do you measure or identify the stopping point?
Yes. The way in which English law has identified the stopping point so far has been by reference to the Latin maxim. And that means that title ends in the centre of the earth. Now, we deal with this argument in paragraphs 35 to 70 of our printed case. And I don't have the time to repeat everything.
Paragraphs what?
35 to 70.
35 to
35 to 70.
35 to 70.
You have seen that the Latin maxim has been criticised. Lord Wilberforce criticised it in the Privy Council, or at least was not complimentary about it. Lord Griffiths, when Mr. Justice Griffiths did not apply it in Bernstein, and indeed not only did he describe it as absurd, but counsel for the claimant, Mr. Gray, as he then was, he himself described the principle as seeming to be absurd. It can be reformulated, which means that you probably don't go down as far as the centre of the earth. A problem with any alternative formulation of the kind that we put forward should avoid, as we submit it can avoid, leading to greater problems than the existing maxim, or that, if one likes, one could put the Latin maxim this way, that the surface owner owns as far down as anybody can at any time reach. And so if there's ever any issue as to anything which happens under the surface, any issue as to ownership, then it belongs to the surface owner, maybe hundreds of years, thousands of years from now, we'll have discovered a way of getting to just above the surface, the centre of the Earth, and if there's any issue as to ownership, then the maxim will then come into play.
My impression is that the maxim causes more problems above the ground than it does below. The overhanging crane, trees, and all these kinds of things, but that there is a fairly consistent line of authority so far as the below ground situation is concerned. And Lord Wilberforce, my recollection is, in the Privy Council case, was content to reformulate the rules, stripping out the Latin in a way that achieved pretty well the same result. I mean, is there any authority that really supports your position as you go down, at least to the depth you have, that you lose touch with the essence of the basic rule that you own the ground beneath the surface as well as the surface itself?
No, I think it's a short answer to that, not so far as English law is concerned. What we seek to do is to apply the approach of Mr. Justice Griffiths to the airspace,
Yes.
to the
Yes.
ground beneath the surface.
Yes.
So far as Lord Wilberforce is concerned, the issue for him was the construction of an Australian taxing statute, a rating statute. And the question was whether, as a matter of statutory interpretation, what was before the court was land within the meaning of the statute or strata within the meaning of the statute. Land was not defined, strata was. It was argued that this could not be land because the owner of it did not own all the way down to the centre of the earth or all the way up to the sky. There was an underground railway underneath the land, for example, and there were bits of the title which were missing. And so it was said this can't be land because the Latin maxim is not satisfied. The decision of the Privy Council was that it was land because the maxim did not have to be satisfied.
I mean, I'm a bit lost about all this. I mean, by definition, assume that that oil hadn't been nationalised, you would be saying, I own the oil under my land. And you would have to own, would you not, the land, the earth above it.
Well, there would have been an issue as to whether or not a service owner owns the oil underneath his land any more than he owns, for example, water or brine underneath his land. But if there is a mineral which can be made use of under a person's land, then the surface owner will have the right to access that mineral. It may be that the surface owner owns all the way down to the mineral and the mineral itself, the seam in which the mineral is to be found. It may well then be the case, but when the surface owner does not own, in this case, the petroleum, and there is no other mineral under his land, then in our submission, his title ends at the point at which he no longer needs to own the ground in order to be able to use the surface.
But just suppose that Bocardo, knowing much more at the beginning of the story than they did, had said, well, I understand there's a chance that the apex of this reservoir is actually under our land. Why don't we set up an exploration company and apply for a license? No doubt there are all sorts of reasons why it wouldn't happen, but if you just consider that possibility, there's no question then they would have been using their land in a way that was technically possible, drilling down to a depth that is possible, and using it. But it's very difficult for you on the facts of this case to say that we're talking about depths where things happen that are no possible use to the landowner, isn't it?
Well, in that case, it would be because Bocardo has a license to exploit the mineral and has therefore the right to go down as far as the mineral in order to exploit it.
But you're not saying that the Crown would license the owner to use its own land to drill. You're not suggesting that there would be a larger royalty there than the royalty on the petroleum extracted, are you?
No, the royalty the royalty would be the same. I think what I haven't done is clear from my head the last argument, and that is that Section 1.1 confers the right to access the petroleum in any event. Our case, our suggestion, is that all that is necessary, so far as land ownership is concerned, is that the owner should not own, if I can put it in a negative way. There's no need for the owner to own anything which is not capable of use and enjoyment, picking up Mr. Justice Griffiths' words, as part of or for the benefit of the surface, or as part of or for the benefit of any buildings or structures on the surface or minerals beneath it. So there's no need for the landowner to be held to own anything which is not capable of use and enjoyment as part of or for the benefit of the surface or buildings on it.
What about the Court of Appeal case of Mitchell against Moseley that Lord Justice Aiken refers to? I mean, we can find our source for this, I think, in paragraph 59 of the Court of Appeal. And Mitchell's case is in volume 6, tab 71.
Yes.
And admittedly, the Court of Appeal there do use the maxim, but it's a Court of Appeal decision applying it in 1914 and saying, in effect, that's quite clear that that is the effect of the common law. We would have to say that was wrong.
On the basis of this, the sort of test for title which I've just suggested, the result would be the same. The Court of Appeal did in Mitchell use the Latin maxim in order, as part of its reasoning, to arrive at the result it arrived at. And one of their Lord Justices, I'm sorry, I haven't turned the case up, but the last of their Lord Justices...
It's the Master of Rolls, Cousin Hardy, I think, who says this.
But the last of the Lord Justices, I think your own copy misses out a bit of the judgment, referred to it as a rule of law. A rule of law of construction, I think is how he put it. You don't, in fact...
Yes, he's put it, it's a construction of a conveyance that he's talking about, yes.
Even on the most generous construction of the most favourable cases for you, which are some of the American cases, you can't answer Lord Walker's point.
Well, I'm not sure that is right. One of the better cases from our point of view, and just find it.
I thought the best one for you was in paragraph 49 about the sewer. Even then it talks about reasonably make use of it, and in this case, Bocardo could apply for a license.
That the ground 150 feet below the surface was not included in the surface owner's title.
Yes, but the reasoning is that it's limited to the extent to which the owner may reasonably make use thereof.
Yes.
Here, Bocardo could have made use.
No, but no. Yes. The distinction I seek to draw is between the title of the mineral owner and the title of the surface owner. If one is simply the surface owner and there are no minerals underneath your land, then your title ends at the point at which you need it to end in order to make use and enjoyment of the surface. If there is a mineral under your land, then your title must also include that mineral. But if there is no mineral under your land and you're simply a surface owner, then there's no reason for your title to descend further downwards than the surface. This does mean that you own further down whether or not there is a mineral under your land. But there it is. That's the only difference between title under the ground and title to the airspace. There is a point, so far as title to the airspace is concerned, where it is said, unless Mr. Justice Griffiths got it wrong, your title ends, or at least you have no rights. You cease to have rights. We say that the same principle applies going downwards. And the only qualification that needs to be made is where there are minerals. And if there are minerals, then your title will include those minerals. But in this case, Bocardo has not shown that there are any minerals under the surface other than the oil. It doesn't own the oil, and therefore it doesn't have any title further down below its land than the title it needs in order to support the surface. That's how we put it. In paragraph 50, you'll see that the US Supreme Court decided that the landowner owns at least as much of the space above the ground as he can occupy or use in connection with the land. And we would say that the principle is therefore the same. The landowner owns at least as much of the ground below the surface as he can occupy or use in connection with the surface, or any minerals which exist below the surface. No minerals, then no title. If at any time it's established.
You're saying, well, the general law of land changed when petroleum was nationalised in 1934 and changed again when coal was nationalised in 1948. Are you? I mean, that's what it amounts to, isn't it?
Well, my Lord, it's not intended to, obviously. My Lord, no. We say that it changed, in effect, with the decision in Bernstein, then followed by the decision, or at any rate the statement of principle, or statement, of Lord Wilberforce in Commissioner for Railways. So far as the Mitchell case is concerned, I may just very quickly...
Sorry. Volume 6, I think.
Go on.
671.
Yeah, 71, I'm sorry, it's taking me so long. Your Lordship's on page 9. Your Lordship see the judgment of Lord Justice Phillimore. In fact, there's some words missed out there. At least there are in my copy. I don't know if there are in yours. After the word, to my mind, sufficiently powerful too, there's some words missing out.
Yeah.
The words missed out are, this is the passage which is in fact relied on, amongst others, to enable us to disregard the recognised rule of law which governs. In my submission, all that the Latin maxim is a presumption or prima facie rule of construction. of conveyances. And prima facie, if there is a dispute between two individuals or more than two, it doesn't have to be two or more, in relation to ownership of a mineral which is established to exist under the ground, then the maxim, which is no more than a rule of construction or a presumption or a prima facie rule, is applied to resolve that dispute. But that applies in the case of an established mineral. What you will see from the case of Mitchell and Moseley is that neither side, neither counsel, disputed the maxim, disputed the applicability of the maxim or the presumption. The presumption is that the surface owner owned the minerals below the surface. There was an established mineral there. It was coal. And the question was whether or not, because of the context in which the conveyance was entered into, conveyance was silent in this respect, title to the minerals did not pass. And that was because there were already leases in existence. So it's a construction question. The Latin maxim wasn't in dispute. The question was whether or not, as a matter of construction, the conveyance did not include the title to the minerals. And the Court of Appeal said there's nothing in the conveyance to exclude title to the minerals, and the surrounding circumstances do not have that effect either. Your Lordship can see our arguments and how we put it. We say that, in essence, this is a rule of construction, the prima facie rule. There is no need, it should not be extended. It should not be applied so as to extend title down to the ground underneath the surface at a point which there are no minerals and no one has any use or enjoyment for them, save, in this case, for the owner of the mineral. The alternative argument, which we set out in paragraph 71 to 92, I must deal with very shortly, is that this is not a proper case because of the depth at which to allow, if I can put it that way, the surface owner to bring a claim in trespass. So ownership I've dealt with. Now the question is whether or not there is a cause of action in trespass. And I think the best way for me to explain this very quickly is to take you to the Court of Appeal.
Just as you're doing that, your proposition, which I think I've grasped, would apply to Crown land as much as anybody else, assuming that there was, leaving aside the statutory vesting of the oil, if it was land that was vested in the Crown. And I'm thinking actually of the seabed. Yes. The proposition would be the same, would it? I mean, land under the sea, you've got a surface of ground which you can put a platform on, or some other structure can rest on the top of the surface. The Crown owns land out there, the Crown estate charges people for moorings and that kind of thing, but yes. You would say that the same law that you've been describing applies there too. The Crown doesn't have an unlimited ownership down to the centre of the earth.
Yes, I would have to. The only qualification, of course, that I have is that it's the Crown, and the underlying basis of English land law, at any rate, is that all title comes from the Crown, and if there is a gap, then the Crown fills it.
I see. Yes, sorry, but anyway, let's move on. So, paragraph 71. It's essentially, I think I can make the point by just taking Your Lordship's first of all, paragraph 66.
in the judgment of the Lord Justice Aikins. He says this in paragraph 66, I'll make this very quick. Having referred to Pi, he says that it follows from this analysis that in the case of the owner of land with paper title, he must be deemed to have exclusive physical possession and the requisite intent to possess the strata beneath the surface to the land he owns, because in the absence of evidence to the contrary, he has a prima facie right to have possession of those strata. It seems to me that these statements don't take one very far once questions about the exclusive physical possession of land and intention to possess arise. In the present case, it's difficult to say that Bocardo has actual possession of the strata beneath the Oxted estate. It has done nothing to reduce those strata into its actual possession. And so I draw attention there to the fact that he says it's difficult to say that Bocardo has actual possession of the strata beneath the Oxted estate. And then later, in paragraph 69, he says, having referred to Anchor Brewhouse, and he then says, I return to the facts of this case. On the face of things, Bocardo is the paper title owner to the strata and all within it. Subject to arguments about the effect of the 1934, it has the prima facie right to possession of those strata, so it is deemed to be in factual possession of them. And I would ask you to contrast that with what the learned Lord Justice said in 66. In the present case, it's difficult to say that Bocardo has actual possession of the strata beneath the Oxted estate. And the simple point that we make, whether or not it's right, is that it is really, first of all, trespass is an interference with possession. It is absurd, I suggest, to consider that the surface owner is in possession of strata 800 feet or more below the surface. To find that he is in possession because of some deeming provision, because of his right of ownership, seems, in our submission, to be a nonsense. The judge was right to say that Bocardo is not in actual possession. Nobody can be in actual possession of land, of ground that far beneath the surface. And it is absurd also to say that such a person has a right to possession when, in fact, there is no real way in which that possession can be enjoyed. So essentially, we say this should not give rise to a claim in trespass. There are other torts, conversion, nuisance, and the reason why a claim in possession and trespass should not run is that no one is in possession of strata that far below the earth or below the surface, and no one has a right to possession of strata which you can't possess. That, in a nutshell, is the point that we make in relation to possession. We make other points as well, but that essentially is it. Those then are the submissions that I make on behalf of Star.
Thank you very much indeed. Mr. Nello.
Nothing more.
Thank you. Mr. Gord.
My Lords, I was going to deal with the damages part of the claim only. My learned friend, Mr. Belloff, will reply to you on trespass. If you require to hear from him on that, I don't know whether you do. If it might be helpful to have an indication, if your Lordships feel able to give one, because then I know how long I've got.
Well, I think briefly, at the moment, there are one or two points raised which we haven't been able to focus on. So perhaps you can give Mr. Belloff 15 minutes or so.
I'll give Mr. Belloff 15 minutes then. I shall be extremely crisp. My Lords, just 3 points which have arisen in the course of this morning, and then I'll go to my learned friend's submissions yesterday. The Pipelines Act is the first one. Your Lordships have my point about the Pipelines Act. I say that the Pipelines Act only applies to pipes which are for the conveyance of minerals, not pipes which are for the searching for, boring for, or getting the petroleum. And that is a distinction which is very clear in the 1966 and 1934 and 1923 Acts, which refer to these activities as discrete activities which they identify. When the Pipelines Act comes along, it only talks about conveyance, and it affects an amendment of the 1923 Act which excludes conveyance by means of a pipe from the 1923 Act. Reading the Acts together, in my submission, the earlier Acts were dealing with the Pipelines Act is only dealing with conveyance of minerals. The earlier Acts deal as well with what I might call the oil well, the creation of the oil well. The Lordships have that point. I won't labour it any more. A new point which arose this morning arises in this way. My learned friend took your Lordships very properly to sections 11 and 12. Section 11 enables the operator to obtain land compulsorily, and my learned friend accepted that that was unlikely to be the right which was being exercised. It was much more likely to be the right to acquire underground rights under Section 12. Now, where Section 12 is concerned, the valuation section is Section 14, to which my learned friend took you. And I recall him as having said, and I may have misheard him, that Section 14 would not enable the landowner to get the value of his land, but only to get damage and disturbance, compensation for damage and disturbance. Actually, Section 14.1 does relate specifically to the value of his land. It says so. It says that if a person entitled to an interest in land proves that the value of his interest is depreciated by reason of the making of the order, the person in whose favour the order was made shall pay him compensation equal to the amount of the depreciation. So now, that's depreciation in value. Now, in this case, at trial and since, we have never investigated what the level of that compensation would be. It would at least be arguable that if the landowner's bargaining rights were being taken away by the making of this kind of order, precisely the same sort of argument that we're having about the other statutes would also apply here. This section does not incorporate the compulsory purchase code or any part of it. It's a standalone provision which says the measure of your compensation is depreciation in value plus disturbance. And what I say is that this has never been investigated in this case. It may well be that that section would enable me to get precisely the same measure of damage as I'm claiming, or precisely the same measure of compensation as under the other statutes that are under consideration. I do not concede that that section means that I can get nothing.
So if you run your pipes under somebody's land, they can have a piece of the action?
They can have a piece of the action. That's at least, I mean, there it is. It's the depreciation in value. Now, we haven't gone into it at any stage. In my submission, we shouldn't be going into it for the first time now. That's all I wanted to add on the question of the Pipelines Act.
Thank you.
On the question of Markham Bain Colliery, it may be a rather peripheral case. I took your Lordships to it because it's interesting in that it occurs in between the 1923 Act and the passing of the 1934 Act, and may well have been in the minds of those responsible for the formulation of the 1934 Act. My learned friend, I think, was suggesting that that was a quite different case because it was a case about the acquisition of minerals, not about the acquisition of rights. That is not, in my submission, right. As against the copyholders, it was a case about the acquisition of rights, because that's all the copyholders had. The copyholder had the right to say, you can't come onto the land which I'm entitled to possession of. I can keep you out. And it was only if they concurred that the colliery owners could get in to get the coal. Even though they'd bought the coal, from the owner of the coal, who was the lord of the manor, they still couldn't get it without the concurrence of the copyholder. And that's what they were buying from the copyholder. So the application that the colliery was making was an application under Section 4.2 of the 1923 Act, under Section 4, rather, of the 1923 Act, and it was an application against the freeholders whose land had not been copyheld land for the right to work the minerals, against the lord for his minerals, and against the copyholder for the right to go in and work the minerals. So we rely on it because it is a very close analogy to the present situation, where the mineral and the right to control access to the mineral are in different hands. It was not, as I think my learned friend was suggesting, as between the lord and the copyholder, some sort of arbitration between them on sort of general contractual principles. It was an application under the terms of the Act. And under the terms of the Act, the copyholder was a person with the, if I can just find the Act, it's 110. It's tab 10 in volume 1, and section 4.2 says, for the purpose of this part of this Act, a person whose concurrence is necessary for the exercise of a right to work minerals shall be deemed to be a person having power to grant the right, or a person from whom the right must be obtained. So there was jurisdiction under the Act to apply as against the copyholder for an ancillary right, because he was a person whose concurrence was necessary for the exercise of the right. That's section 4.2. So it's a small point, but it explains why the copyholder was party to those proceedings, and that the proceedings against him were brought under the Act, and that, of course, engaged section 9.2, which was the section which set the amount of compensation. And far from the copyholder getting nothing, because he had nothing to give, he did have something to give, his concurrence, just as we have something to give, namely our concurrence. And he got 1/3 of the compensation in respect of that part of the land which had been copyheld. So much for Markham. I'll move on. The Mercury Communications case, my learned friend was quite right to point out, was a case concerning a different statutory provision. Of course, His Honour Judge Haig distinguished Ryder. He was unhappy about it. He said if he hadn't been bound by authority, he wouldn't have thought that that was the correct construction of Section 8.2 of the 1966 Act, but he thought he was bound, but he distinguished it. Now, Ryder is important, as I'm sure your lordships are only too well aware, Mercury is important because the learned judge in that case explained very carefully why he thought Ryder was wrongly decided. And he explained that it was on the basis that it turned on two main points. Ryder turned on the notion that the landowner had no bargaining position. That was the first point. And the second point was it turned on what I call the one more bid fallacy.
On the what?
The one more bid fallacy.
Yes, yes.
And that was why the learned judge said that he didn't think Ryder was right. And he goes through it very carefully, he goes through the authorities very carefully, and he comes to that conclusion. And he makes those two very telling points about the decision in Ryder. He also says, and he also points out, that Mr. Justice Peter Gibson did take account of the special position of BP by the award of the extra £5 over existing use value. Now, my learned friend said, well, Mr. Justice Gibson did apply point good. In my submission, it's quite clear that Mr. Justice Gibson did not apply point good. If he was applying point good, he wouldn't have added £5 because he wouldn't have.
I thought his position was that Mr. Justice Peter Gibson was wrong to add £5.
My learned friend was
Yes.
saying Mr. Justice Peter Gibson was wrong to add £5, but was right, he said, to have applied point good. I'm saying he didn't apply point good. Had he applied point good, he wouldn't have added £5. So
Well, because he wouldn't have added anything.
you wouldn't have added anything.
No, quite.
That is one of the odd things about the decision in Ryder, that it seems to have it both ways. It says, on the one hand, the special position of the oil operator, petrol licence holder, is to be taken into account, hence the £5, notwithstanding the fact that he goes to great pains to demonstrate that compulsory purchase principles are to be applied. So it's a very, very confusing decision from that point of view.
Well, I don't think it's any more so than the Indian case, which really seems to say much the same.
Well, my lord, I think everybody in the room can probably agree that the Indian case is the most confusing thing they've ever read. But there we go. Now, it seems to be accepted that absent the 1934 Act, Bocardo would have had a bargaining position that could have been exploited by charging an access payment. And what is said is that Parliament has provided in the 1934 Act for Bocardo to receive what was read out this morning from Hansard, and I quote, full compensation in the sense of the full market value for interfering with the actual rights that exist. That's a quote. Full compensation in the sense of full market value for interfering with the actual rights that exist. It said that Parliament provided me with that, but then in the next breath it said that I get nothing, because there is a general principle that says that you take away the whole value of what would otherwise be my right as a landowner to deny access at depth to my land. Now, which is it? Am I going to get full compensation for a value that I did have at the time of the Act, or am I not? Nothing, or nominal compensation, is a pretty strange sort of full value, full market value. And the important thing about the Act is that, on the one hand, it arrogates to the Crown property in the oil and prevents anybody exploring for the oil or trying to exploit the oil without a Crown licence. But on the other hand, it very carefully reserves in section 10.3 the landowner's rights as a landowner, qua landowner. And it says, the Crown can't confer any rights over a third party's land, and this Act doesn't create any rights over a third party's land, and the petrol licence doesn't create any rights over a third party's land. The land of the third party is inviolate, and if you want to go onto the land of a third party, you have to get an ancillary right, and there's a procedure for doing that. And that procedure provides for compensation. So the case against me seems to reduce to this, that the value that my right to exclude Star would otherwise have had, because of the presence beneath my land of the oil, is to be entirely left out of account for both purposes, for the purpose of compensating me for the acquisition of a right of access to my oil, and secondly, for the purpose of compensating me by way of damages for trespass. So instead of getting the value of what was previously a valuable right, I get nothing. Now, that put baldly, as baldly as that, is a surprising conclusion. What justifies it? Well, what justifies it is reference to a judge-made presumption which is applied when interpreting and applying the compulsory purchase statutes, which start off with the Land Clauses Consolidation Act 1845. Now, the so-called point good rule, as it's been called. The point good rule is a bit of a chameleon, it has to be said. It's been called imprecise. It has been explained in different ways at different times. Sometimes it's expressed by reference to the existence of compulsory purchase powers, sometimes by reference to the exercise of compulsory purchase powers, sometimes by reference to the purpose for which the land is acquired, and sometimes by reference to what is called a scheme. The explanation of it differs. In my submission, what it is essentially, and what your lordships have held it to be in the Spirae's case and the Waters case, is a presumption for preventing overcompensation of the landowner. And it prevents overcompensation of the landowner not by saying the purpose for which the acquiring authority wants the land has to be disregarded. It doesn't say that at all. What it says is the enhanced value, the extra value, entirely due to the particular need of the acquiring authority is to be
Entirely due to what?
Entirely due to the particular need of the acquiring authority is to be disregarded. Now, let me just illustrate this. And suppose there's a valley which is suitable for being converted into a reservoir. The fact that it's suitable for being converted into a reservoir is due to its geographical features. That may well give it a value that pre-exists any scheme of acquisition. Along comes an acquiring authority and says, I would like to acquire that valley for a reservoir. Now, the fact that the acquiring authority wants to do that doesn't necessarily increase its value at all. It may have had that value all along. It had a potentiality, as it's called in the cases, for being used as a reservoir. And the value of a particular field or part of that valley was part of that potentiality. So point good doesn't stop the landowner having the benefit of that potentiality because that potentiality pre-existed the scheme of acquisition. Let us take...
Just on that illustration, I mean, does this suppose that anybody other than a public authority with rights of compulsory acquisition could have translated this valley, I think was yours, into a reservoir?
No, it doesn't depend on there being competitors for the acquiring authority. I'll take your lordship...
So you can say to yourself, I've got a valley which one day, at a public authority at public expense with compulsory purchase powers may want to buy in order to make it a reservoir. I'm therefore entitled to its value as a reservoir or as a potential reservoir. Is that
my lord, at that early stage, that would probably only be a hope value, the sort of hope value that your lordships were considering in the Spirae's case. But when the time comes, perhaps I can illustrate this better with what I might call the backland example, the land which is separated from the highway by a ransom strip. Now, the backland, let us suppose, is suitable for, perhaps it has planning permission for, a supermarket, a Tesco's, a Sainsbury's, a Waitrose, whatever. But in between it and the road, there is a ransom strip. The ransom strip has a value. The owner is unlikely to sell it for its hope value in the hope that one day Waitrose or Tesco's will come along. He's likely to hang on to it until Waitrose or Tesco's, or whoever it is, does come along. Now, at that point, there'll be an owner of the backland, the supermarket site, there'll be the ransom strip. There's only one owner of the backland at the time. There's only one person who wants the ransom strip. He's the owner of the backland. He says, I want the ransom strip. It has a value because I want to develop on the backland, my supermarket. And that'll be a very valuable development, and that gives your ransom strip value. Now that's key value. That's proper key value, which suppose Tesco's can't do a deal with me because I'm asking for too much money, and they go to the local authority and they get the local authority to promote, for planning purposes, a compulsory purchase order to help Tesco's, often done. And the compulsory purchase order is promoted in order to promote the development of this land for a supermarket. The fact that the acquiring authority on behalf of Tesco's is the only person who wants it doesn't matter. The value is created by the geographical situation, by the fact that the backland is suitable for development and my land is the only means of access to it. That's what gives it its value. It's not the scheme of acquisition that gives it its value in that example. It's its geographical location and the fact that I have the access. Now that's exactly the situation that arose in the Chapman and Chichester case. I won't take your lordships to it again, you have it. Exactly the situation. And the tribunal in that case said, well, I say exactly, it wasn't a supermarket, it was a housing development. But in that case, the Lands Tribunal said, no, this isn't a case for the application of point good. This isn't a case for the application of Rule 3. This is a case where the value is created by the geographical location and the fact that the only access is across the ransom strip.
It maybe in one way it strikes me that it depends when you test this question. If you test it at the moment immediately before the negotiation, when the scheme is up and running, as it were, well, there's already a licence, and the 1934 Act is already in force. One could say with perhaps Lord Justice Sullivan, whoever it was in the Court of Appeal, well, it's really the price of the licence. It's intimately,
yes.
The value is intimate,
well,
now at any rate,
yes.
It's intimately caught up in this scheme.
The value is generated by the licence, that's the notion.
Yeah.
Well, the reply to that is the value is not generated by the licence. Neither is the value generated by the Act. And let me go straight to that and meet that head on. Let me go back to before 1934, ignore the 19 Act for the time being. There I was, or there my predecessor was, as the owner of the land. In 1934, what happens? Parliament says the oil under your land now belongs to the Crown. That hasn't increased the value of my land. That hasn't increased the value of the access rights to my land. If anything, it's decreased it. So the Act hasn't. The Act, if the Act is part of some scheme, the Act has not increased the value. Subsequently, a petroleum licence is granted to an oil operator, to Star, or its predecessor. That doesn't increase the value either. That hasn't increased the value of my land one iota. All that has done is identify the operator who wants access, or who may want access at some time in the future. In fact, there was quite a gap of nearly 10 years. So far, nothing has happened to generate value. Well, the next thing that happens is that Star comes to me, or should have come to me, and says, I'd like to get into your land. At that time, we negotiate. Nothing has happened to increase the potentiality of my land. The potentiality has remained the same all along. I'm only talking about the access right. I'm not talking about the oil at all. The oil isn't mine. What normally happens in these cases is that there's a scheme of acquisition, the so-called scheme that has to be put on one side, is a scheme of development. It's not a legislative scheme. And the scheme of development may have increased the value of the land, as was argued in the wetlands case, because it said this probably not very valuable area on the edge of the River Severn is absolutely vital to the Cardiff Bay Barrage, which is a very important project. You can't do it without it, therefore up goes its value. No, says the court, it was part of the scheme. I'm not saying that at all. What is said against me, to use the expression taken from the judgment of the Court of Appeal, what is said against me is that there is extra value because of the exploitation of the petroleum license. The petroleum license, the exploitation of the petroleum license was the scheme. That's what the Court of Appeal say. But it's not the exploitation of the petroleum license that gives my land its value. It's the exploitation of the oil fields that gives my land its value. The oil field was there from the start. The point about point good is it only comes into play to strip out the enhanced value.
Where is that most clearly stated?
Where is...
Where is the enhanced value point clearly stated? That the purpose of the point good...
everywhere. I'm sorry, my lord, to be flippant.
Well, in that case,
I don't mean to be unhelpful. But every time the point good principle is stated, it's made it clear that it's the enhanced value entirely due to the scheme.
I think it entirely was the word used by Lord McDermott in Point Good himself, and has been much repeated, and Lord Nichols used the word solely, I think, when he described it in Waters.
Yes, but there may well be a value to the acquirer, there may well be a value for the purpose for which the acquirer wants it. Which value would be applicable, whoever the acquirer was? That is not stripped out. It's only enhanced extra value generated by the scheme, because the view taken is, well, Parliament can't have intended to give compensation to landowners when the scheme of acquisition had pushed up the value of their land and thereby created a value which didn't exist. Now, that's not the case here. There's no scheme of acquisition here at all. There's no scheme. What gives the land its value is the exploitation of the oil field. It's not the exploitation of the license. It's not the act. It's none of that. None of that adds value.
I mean, what's that against you is, just assume, as here, you acquire this land after the oil has been expropriated, after the right to get the oil has been expropriated. You have then, at that point, you've got land with none of those rights at all.
Yes.
And it isn't until somebody grants a license, as here, the scheme, as the Court of Appeal found it to be, that you have any possible value. That's the enhancement. It gives you a value in this substrata that you never had before, assuming that it's worth anything.
My lord, my first point in answer to your lordship is the right to get at the oil has not been expropriated. The effect of section 10.3 says that if the oil company wants to come onto my land to get at the oil, they have to get an ancillary right.
Well, the exclusive right of searching and boring for and getting it has been expropriated.
Yes, well, that's right, but that doesn't give them the right to come onto my land. The Act says so. Section 10.3 says so, in terms. And I mean, it might have been thought, if it had not been for 10.3, that Section 1 had exactly that effect. It talks about the right to search for and bore and so on. And people might well have turned around and said, well, OK, the Act has given that to the Crown. The Crown can grant a licence to whoever they like. Whoever gets a licence can go onto any land they like and do these things. That's the effect of the licence. But Section 10.3 says that is not the effect of the licence. That the Crown has no right to grant such a licence. And that is not the effect of the licence. So my right to say no, my right to say keep off my land is not expropriated by the Act. What happens is that under the Act, there is encouragement to parties where an ancillary right is required to negotiate, because unless they do, the jurisdiction in the Act go to the Minister, and the Minister to refer the matter to the court is not triggered. And at that point, the oil company can go to the court and get compensation. But the compensation they get is by reference to a bargain in the open market between willing their soil, willing their sea, on fair and reasonable terms.
It's a huge weight on 10.3. Narrowly you survive, let's postulate, the argument that it doesn't actually reserve you anything of relevance in the present case. Assume that, but you then say, not only does it preserve you that, but it preserves you, therefore, the right to get a piece of the action, as for convenience, shorthand, once calling it.
But it does preserve for me a right to get a suitable rent for permitting access.
I mean, there isn't much in the contemporary parliamentary debates to suggest that's the correct view of 10.3.
No.
Well, 10.3 was introduced as a government amendment, wasn't it? Don't we see that?
I'm not sure if it was I'm not sure if it was an amendment. Your Lordship may be right that it was an amendment, but it was certainly a government policy, and the government, in the passage that we refer to in our case, made it very, very clear that the licence was not going to allow the licensee to go onto other people's land. Now, at the time, no doubt they weren't thinking about
I think it's tab 155, page 390. It appears to me to show that it was a government amendment.
Volume 9, is it?
30, isn't it?
Volume 13, tab 155,
yeah.
page
I'm very
390.
Yes. 390, and I think it becomes even clearer later.
Oh, yes.
The Crown, yes,
Yes.
I think we've sidelined the passages, haven't we? The questions which the noble Lord asked me are directed to three principal points. The first is to ensure the Crown should be put in no better position under the bill than a person who obtains a licence under Clause 2, and who is obliged, if he wishes to enter upon or interfere with land, to obtain an ancillary right under Clause 3. I've put down an amendment myself to remove any possible doubt, and this point, therefore, will be dealt with when we reach the amendment. So your Lordship's absolutely right, it was a government amendment. So there's what became 10.3. Then at page 394, there's another passage. I regret to say that on the second reading, I couldn't have made myself clear to the majority of your Lordships. The first of those 2 points is this. I'd like to emphasise once more that the issue of a licence confers no sort of right on the licensee to enter upon anybody's property. That's a matter which I think your Lordships have hardly appreciated as yet. We believe, and we are legally advised, that the bill as drafted makes this quite clear. But in order to make doubly certain, the government have put down an amendment which I shall move shortly. The right of access to land has to be acquired quite independently of the licence. So I was rather diffident about referring to that earlier, because it seemed to me that the provisions of clause of section 10.3 were very clear, and that on the principles your Lordships have laid down for looking at parliamentary debates, I was probably not entitled to do so. But then we've looked at it. And, that's what it says. My Lord, it is curious, this. Point good, this rather slippery principle, which is called point good, is there to avoid overcompensating the landowner. But let's look at what it is said it does in this case. It completely deprives the landowner of what I think it is now accepted is a valuable right, namely the right to say no to the oil company. And it results, therefore, in the landowner...
Sorry, but has he the right to say no?
Yes, he does have the right to say no.
But it's... I'm sorry, well, yes, I'm sorry, I'm sorry.
Yes, I'm sorry, my Lord, I didn't mean to be...
Until he's compulsorily deprived of it. Yes, of course,
until the procedure in the Act is implemented, yes, of course. And
at the time and on the basis of the in accordance with the rules of the hypothetical negotiation.
Yes. The hypothetical negotiation is, let's remove it from the Act. It's happening hypothetically. And it is not against the background of an Act which says you have no veto. It is an open market, unconstrained, unforced bargain in which the parties are willing, they are not compelled to deal. That's what willing means, not compelled to deal. They are not reluctant, they are not over anxious, they are not compelled, they are willing. And if my learned friend's application of the point good rule is right, not only do I not get overcompensated, I get spectacularly undercompensated because I get nothing. I have the right to say no. I have the right to bargain. I have the right to say I have a property right I have the ability to grant you the easement you want to get at your oil, and that must be worth something to you. Now let's talk about what it's worth to you and what it's worth your while to pay me. And £82.50 is not the answer. The answer is something substantial, related to, no doubt, the anticipated profitability of the oil field. Now, we went about working out what that would be in our expert evidence, and BP and Ryder apart, we reached agreement with the other side as to what sort of deal would be done and at what level. What is now said is, well, that's all very well, but BP and Ryder says you have got to ignore the fact that the oil operator is the person bidding for this right because he's part of a scheme. What I wrote down as my learned friend's submission yesterday afternoon was this: the land has a ransom or key value, but the only person who can be ransomed is the licence holder, and he must be disregarded because he is part of the scheme. That seems to be the nub of the case against me. Now, we don't resile from the submissions we made before, which are that the compulsory purchase code is not incorporated here. What you have here is a standalone section which itself has a built-in safeguard against overcompensation. The built-in safeguard is it's got to be fair and reasonable, and the parties have got to be willing. So it's not going to be an exorbitant price. That's not allowed. It's an express direction against overcompensation. You don't need point good. But nor do we resile from the submission that the compulsory purchase statutes, the compulsory purchase code, which contains all sorts of point good elements. I mean, this is something we haven't really explored in this hearing, but not only is there Rule 3, but there is Section 6, there is Section 9 of the Act. There are all sorts of assumptions and disregards in the Act which are related to point good, which are aspects of point good. None of that is involved. What is said is that there's a standalone principle outside the terms of the Compulsory Purchase Act which can be applied across to this Act. And we say that is a really strange way to go about construing a statute. The right way to go about construing a statute which deprives, expropriates rights of a landowner is the principle that Parliament does not expropriate rights without compensation and shouldn't be held to have done so in the absence of very clear wording. That's the general principle. Now here, there is no such very clear wording at all. What we have is a formula, fair and reasonable between willing grantor and willing grantee, which seems to be quite comprehensible as it stands, and no wording that points the other way. The wording points, in my submission, our way. The wording says we should have fair and reasonable compensation. Not nothing. But
the argument you've been advancing up until now this afternoon assumes that's wrong.
It does.
Doesn't it? It assumes that this is a compensation statute, see section 3(2)(b), for example, and therefore it's the kind of statute to which the courts, for good or ill, have applied the point good principle.
Your Lordship's absolutely...
See the recent decisions of their Lordship's House.
Yes.
And that the question then is whether or not this scheme falls foul of it or not. And that's the point you've been debating this afternoon. That's right, isn't it?
My Lord, you're absolutely right about that. I just didn't want it to be overlooked that I also argue that these principles are not applicable here. But if they are, if point good is applicable, then one has to look to see how it would, if the principle is in principle applicable, it would apply in practice. And
is it relevant that your clients only became the owners of the land long after the 1934 Act was passed?
No, it's not.
You seek to test the question, if you like, immediately before the 1934 Act, first of all, and then say, well, what would be the position as between the then parties after it?
Yes.
You say that once you've decided that, nothing that happens subsequently alters the position.
Well, no, it doesn't, because it's perfectly true that when I acquire the land, I don't acquire it with rights in the oil. But I never suggested I did. All I'm saying is that I acquired the land with the usual landowner's rights not to have people trespass. That being so, if they want to trespass, then they have to come and deal with me. What deal I do will depend on what right they want and what I think it's worth to them and what they can convince me I ought to accept. But it's a matter of bargaining and negotiation. I must be very swift because my learned friend is keen to address your lordships. Could I, without taking your lordships to any of these passages, could I just ask your lordship to note some certain things? When citing the Indian case to your lordships, I passed over rather swiftly what might be called the Fletcher-Moulton-Vaughan-Williams debate. There is a long passage in the Indian case, in the speech of Lord Raymer, at pages 318 to 323, which deals explicitly with the submission that if there is only one party interested, namely the acquiring authority, his bid must be left out of account. Now that is very important now in the light of my learned friend Mr. Driscoll's submissions, because that essentially is his case. He says there's only one bidder, namely the petroleum licensee, and his bid must be left out of account. That point is expressly addressed in the Indian case and rejected. That is the Fletcher-Moulton point of view. Lord Justice Vaughan-Williams did not agree, and Lord Raymer investigates it, and the whole court rejects it explicitly and resoundingly at page 323. Now, my learned friend placed considerable stress on re Naylor Benson. We discuss re Naylor Benson in some detail at page 59 of our printed case in Annex 2. We say it was wrongly decided for the reasons we there give, but it was followed in Ryder, and it was followed by the Court of Appeal in this case. It was cogently criticised in Mercury.
In what?
In Mercury. In
Mercury. Yeah.
Mr. Haig's decision in Mercury. And in your lordship's copy of the report, it's the discussion of Naylor Benson is at page 13 of Mercury, and in the Estates Gazette Law Report, it's page 235 G to M. We say Naylor Benson was wrongly decided for all the reasons that are given by Mr. Haig and that are given by us. Not one of those reasons is that a previous case on the same statute called Reconset was not cited, and that was a case in which Mr. Justice Finlay made a very interesting observation. It was an access case, it was not a minerals case, it was a wayleave case. And the submission was made, compulsory purchase principles apply, point good, and so on and so forth. And Mr. Justice Finlay said, well, if Lord Justice Fletcher-Moulton's principle is right, then the need of the only person who wants the wayleave will have to be left out of account. The wayleave was, I think it was an overhead ropeway to carry coal from a colliery. Not quite sure, I may have misremembered that, but it was that sort of right. And he says, well, on the Fletcher-Moulton principle, you'd have to leave out of account the only person who wants the wayleave. Well, if you do that, it's not worth anything. And that can't be right, and he did not go down that route. And he said, as did Mr. Haig in Mercury, the right thing to do is set aside all this debate about compulsory purchase statutes and construe the Act that we're dealing with. And that's what he did. absolutely finally, could I just say a word about Mr. Driscoll's 6 principles? I have probably said all I need to say about the first 4. But Mr. Driscoll's 5th principle is the proposition that the nationalisation of oil in 1934, together with the grant of the exclusive right to the Crown to bore for and search for and get petroleum, deprived the landowner of any value that there might have been in his land because there was an oil reservoir under it. From 1934 onwards, the only means of exploiting the oil was through the statutory scheme of licensing. I say wrong. It didn't. Section 10.3 means that it did not deprive my land of any value there might have been because there was an oil reservoir underneath it. Even the Court of Appeal would have given me £82.50, or indeed, to avoid having to go under the Act, £1,000. Even Mr. Justice Peter Gibson would have given me some sort of solatium to compensate me for the fact that the oil reservoir was underneath. And Section 10.3 very carefully lets the landowner keep the right to negotiate for and receive a price for the ancillary right which the oil company wants. So I challenge my learned friend's proposition 5, and I challenge his proposition 6 too. His proposition 6 is if one ignores the value of the right to the acquirer, the right to drill pipes through the substrata is of non-existent value. In a no-scheme world, there is no market for it. If one ignores the value of the right to the acquirer, no formulation of point good says you have to ignore the value of the right to the acquirer. What you have to ignore is the enhanced value.
Is what?
Is the enhanced value, which is entirely due to the scheme of compulsory acquisition, if there is a scheme of compulsory acquisition. But there is no reason to ignore the value of the right to the acquirer, and indeed, Lord Raymer in the Indian case says you do not ignore the value of the right to the acquiring authority, even if they are the only bidder. My lords, I must let my learned friend have
Yes.
the odd minute.
Thank you very much, Mr. Gordon. Mr. Bell.
My Lords, in the parliamentary debates on what became the Act of 1934, as my Lord Brown observed, it's in volume 13 at page 156, Mr. Runciman, in describing what he said was generous compensation due to the landowner under the bill, in the same column, contemplated the possibility of drilling down to a depth of 10,000 feet. In this case, as the statement of fact shows, the drilling was only to a depth of 3,000 feet. And if my learned friend Mr. Driscoll's argument and trespass be right, then the compensation, whether described as generous or otherwise, would not be available at all at a depth 7,000 feet short of that which Mr. Runciman apparently contemplated it might be. Now, in our submission, the so-called trespass issue, however it is bisected, is entirely subsumed within the issue of whether or not Bocardo owned the land down to 3,000 feet, which ex hypothesi could be accessed, as we know that Starr did. I say that because if one goes back at this juncture to the pleadings, I simply give your lordships the reference. It's paragraph 11 of the defence at page 93 of Appendix 1. What is averred is the defendant's activities take place at such depth that land at this level is not within the ownership of the claimant. It is accordingly averred that the claimant cannot maintain an action in trespass against the defendant, as the claimant has no right to enter into possession of the land utilised by the defendants. So in our respectful submission, the reasoning is as follows: because no ownership, therefore no right to enter in possession, and therefore no action in trespass. Now, my lords, we deal with the question as to whether we have a right of action in trespass between paragraphs 140 and 145 of our printed case. And we submit that it is axiomatic that whether one enjoys possession or a right to possession, one can bring an action for trespass. To give an obvious example of the latter category, the landlord can bring an action for trespass against a tenant who holds over at the conclusion of a lease, even though in that situation the landlord clearly does not enjoy possession, but merely the right to it. Now, we submit that the right to possession does in fact derive from a title. But if one needed to go further than that, in our respectful submission, possession of the substratum would be indicated by exercising control as far as it was possible to do so, and that in the case of a landowner would be by excluding persons from the surface and thereby disabling them from drilling directly from the surface land in the ownership of the landowner.
You mean by that simply to assert your
exactly.
right of ownership and say, don't go there without my permission?
Yes,
That's good
it's
enough.
obviously impractical to envisage some kind of subterranean barrier in order to exert that degree of control. Insofar as intention to control is of any relevance at all, your lordships will know from the statement of facts at paragraph 18 that there was a measure of concealment by Star or their predecessors of their activities the moment those activities were discovered. Bocardo instituted proceedings. One could not have a more vivid illustration of the fact that they intended to protect their rights. My lords, can I just ask your lordships, when you consider this particular issue, to bear in mind two cases, Pye and Graham, which is in volume 7 at tab 83, in particular in the leading speech of Lord Brown-Wilkinson, paragraphs 31, 38, and 42 to 43, and also Powell, same volume, volume 7, tab 81, and the passage at the centre of page 12 of the printout, where Mr. Justice Slade, as he then was, shows how easy it is for an owner to establish a desire to maintain the right to possession, and indeed suggests that the onus lies on those who would say that by some way he's indicated a disinclination to maintain that right. If your lordships wish for authority for the proposition that he who possesses the surface land possesses the substratum, Sir Frederick Pollock's analysis in his classic Law of Possession, tab 177 in volume 14, and also the cases we cite in footnote 89 of our printed case, establish the proposition. One asks forensically, how can the depth of the substratum alter the principle that is there adhered to? Now, on the other limb, we ask your lordships to look at paragraphs 111 to 140 of our printed case. And we say, with great respect, the Latin maxim, translated no doubt into convenient English, although it has been criticised, does remain the guiding principle. My learned friend referred to the speech of Lord Wilberforce, but in paragraph 116, your lordships will know that even Lord Wilberforce was prepared to accept that the statement could be used as a statement imprecise enough of the extent of the rights prima facie of the owner of land, thereby, in our respectful submission, recognising that he who owns the surface owns the substratum and making no adverse comments in relation to depth. My learned friend referred to Bernstein, Mr. Justice Griffith as he then was. We deal with the differences between the issues that arise in terms of upward ownership as distinct from downward ownership at a paragraph, there are printed case at paragraph 125. Can I also ask your lordships to bear in mind what was said by Lord Justice Aikins at 62 and 68 of his leading judgment, what is said by Professor Friedman, volume 14, tab 165, what is said by McGarry and Wade, volume 14, tab 186, and what is said in Stair's Encyclopedia at volume 14, 178, all of which emphasize the policy differences and the practical differences between issues that arise looking upwards and looking downwards. There's also, insofar as Mr. Justice Griffiths espoused an ordinary use and enjoyment test and a balance of interest test, which in our respectful submission blurs the boundary between nuisance and trespass, one will see a corrective judgment in Anchor, Volume 3, tab 24, by Mr. Justice Scott, as he then was, confining the Bernstein decision to its special facts and being unwilling to suggest that ordinary use and enjoyment was a test even upwards, let alone downwards. My learned friend conceded there is no English authority at all in favour of his broader proposition. The only authorities he relies upon are United States cases. In one, Edwards and Sims, volume 13, tab 131, he's compelled to rely upon a dissent. The only two cases involving considerations of downwards issues are Beringer at tab 121 and Chance at tab 124 in volume 12. They are both state judge cases, with great respect to them, and even as my Lord Collins pointed out, on the Beringer test, Bocardo would still succeed. I'm bound to observe, in respect of American jurisprudence, tot judices quod sententiae, one can find authority for virtually any proposition one wishes. Mitchell and Mosley, penultimately, volume 6, tab 71, it is a recognised rule of law, so described by a very distinguished court of appeal. My learned friend seeks to relegate it to a rule of construction, but the rule of construction of conveyance is in fact founded in this instance on substantive law. So what one has at the end of the day is this. My learned friend Mr. Driscoll seeks to substitute for a test that is certain, that is practical, that is well established throughout the Commonwealth and has been for several centuries, the one which is complex, uncertain, as we suggest that paragraph 129 of our printed case, impracticable, has only quite exceptional United States authority to support it, that is not a journey down which, in our respectful submission, your Lordship should in this case travel. Unless I can assist your Lordships further, those are my responses on the trespass issue.
Thank you very much indeed. Well, we're extremely grateful to Council for their assistance during the past 3 days in this extremely interesting and important case. We will take time to consider our decision.